Welcome to this in-depth guide on U.S. visa overstays. First, we will clarify the critical difference between being formally banned and having your visa automatically canceled. Next, we will examine technical overstays, the 180-day and 1-year thresholds, and how Section 222G works. Then, we will talk about the burden of proof and what to do if you suspect an overstay. Finally, we will test your knowledge with quick quizzes and wrap up with key takeaways. Let's get started. In this agenda, we will first distinguish formal bans from automatic visa cancellations under Section 222G. Subsequently, we will address the thresholds that trigger 3- and 10-year bars. After that, we will discuss the traveler's burden of proof and practical risks at the border. Then, we will provide a step-by-step action plan to reduce risk. Lastly, we will include short quizzes to reinforce the key points. Before we dive in, it is important to state that the content here is for informational purposes only and does not constitute legal advice. Because immigration outcomes depend on specific facts and current policies, you should consult a licensed immigration attorney to review your history, documents, and risks. With that in mind, let us proceed carefully and focus on understanding the key differences that affect your options. Let us distinguish the two outcomes. A formal ban, often tied to removal or deportation proceedings, typically includes signed paperwork acknowledging the removal, and a defined inadmissibility period, such as 3, 5, or 10 years. Conversely, if officers allowed you to leave voluntarily without having you sign removal documents, you were likely not formally banned. However, this does not mean there are no consequences. Under Section 222G, an overstay automatically cancels your non-immigrant visa, rendering it void. As a result, you cannot rely on that visa for future entry, and must apply for a new one in your country of nationality or residence. This distinction is crucial, because many travelers confuse the absence of a ban with the absence of consequences. This timeline shows how the duration of an overstay changes the consequences. Initially, while your stay is valid, there is no issue. Once you pass the authorized date, Section 222G will void your non-immigrant visa, even if you are under the 180-day mark. If you overstay between 180 and 364 days, and then depart, you typically trigger a 3-year bar to re-entry. If you accumulate 365 days or more of unlawful presence, and then depart, you typically trigger a 10-year bar. Importantly, voluntary departure does not erase inadmissibility. It simply avoids immediate formal removal proceedings. Therefore, timing is critical, and precise day counts matter immensely. Technical overstays occur when details like multiple short trips, same-day border re-entries, or misinterpretation of arrival and departure records accumulate. Although your passport may show departure stamps, officers also examine electronic systems, such as I-94 records, airline manifests, and border crossing logs. As a result, the arithmetic can surprise travelers by pushing them past the 180-day threshold without realizing it. Furthermore, being allowed to depart does not equate to compliance. It may simply be the least resource-intensive option for the government at that moment. Later, when you attempt to return, those alleged overstays can surface and lead to refusal of admission. On the left, a formal ban or removal is typically documented through signed paperwork and comes with a defined inadmissibility period, such as 3, 5, or 10 years. Overcoming it may require a waiver, and it often creates a heavy procedural and documentary trail that can follow you for years. On the right, Section 222G. Cancellation is not a formal ban, but still voids the visa upon overstay. Although it does not specify a fixed inadmissibility period by itself, it obligates the traveler to apply for a new visa in the home country and invites heightened scrutiny. In practice, both outcomes lead to obstacles, but a formal ban is usually more severe and legally explicit. In all non-immigrant entries, the burden of proof rests on the traveler to demonstrate admissibility. If your visa was voided by Section 222G, attempting to use it again is dangerous and may lead to immediate refusal of admission. Border and consular officers typically have access to your arrival and departure records and can triangulate them with airline data and prior applications. If they detect inconsistencies or suspect status violations, they may decline entry or deny new visas. Consequently, after an overstay event, repairing credibility takes time, documentation, and a clear narrative supported by evidence. Here is a practical plan. First, compute the exact number of days you were present in the United States for all relevant trips. Do not estimate. Use calendars and documents. Second, retrieve I-94 records and collect evidence such as boarding passes, entry and exit stamps, hotel invoices, pay stubs, or other corroboration. Third, if you suspect a violation, speak with a licensed immigration attorney before scheduling travel or submitting applications. Fourth, avoid applying for a new visa immediately after an overstay because an immediate application is likely to raise red flags and lead to refusal. Finally, build a clear timeline and organize your evidence into a binder so that your account is consistent and defensible. This table summarizes typical outcomes for an overstay under 180 days. Section 222G voids the visa even though the 3 or 10-year bar is not triggered solely by that duration. For overstays between 180 and 364 days, departure usually triggers a 3-year bar. At 365 days or more, departure usually triggers a 10-year bar. In all overstay cases, the existing visa is void, and a new application in the home country is required. Where no overstay occurred, the visa remains valid, but meticulous documentation and continued compliance are essential. This Mindmap places prove admissibility at the center and branches into 6 evidence categories. Identity includes your passport and any national identification. Travel records encompass I-94 retrievals, boarding passes, and itineraries. Status documents include the visa page, program documents such as DS-2019 or I-20 if relevant, and any approved extensions. Timelines focus on date-by-date calendars and precise day calculations. Supporting proof contains hotel invoices, payroll records, or utility bills that corroborate presence or absence. Finally, professional help refers to an attorney's letter or legal opinion to synthesize the facts and applicable law. Together, these branches form a comprehensive evidence strategy. Question: if you left the United States voluntarily without signing removal paperwork, but stayed 10 days beyond your authorized period, what likely happened to your visa under Section 222G? Options: A. Nothing. Your visa remains valid. B. It was automatically canceled and is now void. C. You received a 10-year ban. D. You are permanently barred forever. You may pause the video now to think about the answer. We will discuss the correct answer in the next section of the video. The correct answer is B. Under Section 222G, even a short overstay automatically cancels your non-immigrant visa. While you may not have a formal ban, you cannot rely on that visa for future entry and must reapply in your home country. Question: you overstayed for about 200 days and then departed voluntarily. What bar, if any, was likely triggered by your departure? Options: A. No bar at all. B. A 3-year bar. C. A 5-year bar. D. A 10-year bar. You may pause the video now to consider your answer. We will reveal and explain the correct answer in the next section of the video. The correct answer is B. A 3-year bar. When unlawful presence reaches at least 180 days but less than 1 year, departure typically triggers a 3-year inadmissibility bar. If the overstay had been 1 year or more, the bar would generally be 10 years. Here are the key points. A formal ban is generally documented by signed removal paperwork and includes a 3, 5, or 10-year inadmissibility period. Any overstay triggers Section 222G, which automatically voids the non-immigrant visa. Overstays of 180 to 364 days typically trigger a 3-year bar upon departure, while a year or more typically triggers a 10-year bar. The burden of proof lies with the traveler, so accurate records and consistent timelines are essential. Before taking any action, consult with a qualified immigration attorney. To conclude, remember that a formal ban and a 222G cancellation are different outcomes with distinct implications. Even if you left voluntarily, an overstay can still void your visa. Because day counts and documentation are decisive, you should track your time precisely, retrieve records, and build a coherent narrative. If anything is unclear, consult an immigration attorney before you travel or reapply. Now, let us close with a final message. Thank you for watching. If this video was helpful, please like, share, and subscribe for more practical guidance. Additionally, tell us about your experiences and questions in the comments. Your insights can support others who are navigating similar situations. See you in the next video.